You've heard the words before you ever saw them used for real. You have the right to remain silent. Maybe from a cop show, maybe from a movie, maybe just from being alive in America. It's one of those phrases that feels older than the country itself, like it was baked into the Constitution the day the ink dried. It wasn't. For almost 200 years, through the Revolution, the Civil War, 2 World Wars, police in this country could arrest you, sit you down in a room, and interrogate you for as long as they wanted, without saying a single word about your rights. No warning, no lawyer, no requirement to tell you that anything you said could be used against you. Nothing. So what actually happened in that room? What did an interrogation look like before anyone had to explain your rights to you first? And what, exactly, forced that to change? Was it a law? A protest? A vote in Congress? No. It was one case, one confession, one deeply unlikable man who, ironically, became the reason every arrest in America now sounds the same. Before we get there, though, picture the ingredients: rubber hoses and locked doors. A federal report that admitted, in writing, what police were doing behind them. A whipping so brutal it reached the Supreme Court. A quiet case out of Chicago that cracked the door open just a little. And then the case that blew it off the hinges, a rapist's confession, of all things, that ended up rewriting how every police interrogation in America has to work. And if you think that's where the irony ends, it isn't. Wait until you hear how this story actually finishes. Here's the truth at the center of all of it. The words you assume have always protected you the moment police put you in handcuffs didn't exist for most of this country's history. They came from one ugly, ordinary criminal case. And understanding how we got there tells you a lot about who actually holds the power in the smallest, most closed-off room in the justice system. So let's go back. Not to 1966. Further than that, back to the early 1900s, when American policing didn't really have rules for what happened once the doors closed. There was a term for it, and cops used it openly, without embarrassment: the third degree. It wasn't a euphemism they thought they needed to hide. It was just the method. You'd get picked up, brought into a back room, and the questioning would start. And if you didn't talk fast enough, or didn't say what they wanted to hear, things escalated. Beatings were common, not always dramatic ones. Sometimes it was a fist. Sometimes it was a phone book pressed against your back so the blows wouldn't leave a mark. Sometimes it was a rubber hose, chosen specifically because rubber doesn't bruise the way a bare hand does. Sometimes it wasn't physical at all, just hours and hours of isolation. No food, no sleep, no clock on the wall, just the same 2 or 3 questions over and over until you were too exhausted to keep saying no. And here's the part that's hard to sit with. None of this was some rogue hidden practice run by a few bad cops in a few bad cities. It was standard. Common enough that it had its own name. Common enough that prosecutors built entire cases around confessions that came out of those rooms. And judges, more often than not, let them stand. Because there was no rule saying they couldn't. Think about that for a second. If a confession existed, if it was signed, if it sounded plausible, that was usually enough. Nobody in the courtroom was required to ask how it was obtained, whether the person confessing had slept in 2 days, whether they'd been hit, whether they even understood what they were confessing to. This is the world police interrogation lived in for decades. Not an occasional abuse of power, a system that simply had no guardrails yet, because nobody in a position of authority had been forced to build any. And for a long time, that was just accepted, quietly. the way something ugly gets accepted when it's happening to people without the power to be believed. But eventually, it got hard to pretend nobody knew. By the late 1920s, the rumors about the third degree had gotten loud enough that the federal government couldn't just look away anymore. So in 1929, President Herbert Hoover created a commission to investigate, officially called the National Commission on Law Observance and Enforcement, though almost nobody remembers that name. Everyone just called it the Wickersham Commission, after the man who ran it, George Wickersham. And in 1931, that commission published a report, a specific one, dedicated entirely to police interrogation methods, bluntly titled Report on Lawlessness in Law Enforcement. Read that title again. This wasn't an outside watchdog making accusations. This was the federal government, in its own report, using the word lawlessness to describe the police. The report laid it out in detail. Beatings, sleep deprivation, suspects held for days without access to a lawyer, a phone call, or a judge. It confirmed, in official language, everything that had been whispered about for years, that the third degree wasn't a myth, wasn't exaggeration, wasn't a few bad precincts. It was routine, and it was happening in police departments across the country. For a moment, it felt like something might actually change. But here's the uncomfortable part. A report isn't a law. It doesn't come with handcuffs of its own. The Wickersham Commission could describe the problem in as much devastating detail as it wanted. It had no power to force a single department to stop doing any of it. No penalties, no enforcement mechanism, no court requiring compliance. So, departments read it, or didn't. Some quietly cleaned up their act, at least on paper. Many didn't change a thing, because there was still no actual rule saying they had to. The report did something real, though, even if it wasn't what people expected. It took away the excuse of, "we didn't know." After 1931, nobody in a position of power could credibly claim ignorance about what was happening in interrogation rooms. The problem was documented, public, and undeniable. What it didn't do was give anyone a legal weapon to actually stop it. That weapon would come from somewhere else entirely. Not a commission, not a report, but an actual court case with actual defendants whose treatment was so brutal that even a Supreme Court that had stayed quiet on this issue for over a century couldn't look away. 5 years after the Wickersham Report, the Supreme Court finally got a case ugly enough that it couldn't be ignored. It came out of Mississippi in 1934. 3 black tenant farmers, Ed Brown, Henry Shields, and Arthur Ellington, were arrested for the murder of a white farmer. And arrested barely covers what actually happened next. Deputies took each of them, one at a time, and whipped them until they confessed. Not roughed up, not intimidated. Whipped with leather straps that had metal buckles attached, according to the trial record, until they agreed to say what the deputies wanted to hear. One of the men was strung up by a rope, let down, then whipped again when his first confession wasn't the one the deputies wanted. And here's the detail that should stop you cold. None of this was hidden. The deputies didn't deny it happened. At trial, one of them was asked, under oath, how severely the defendant had been whipped. His answer, more or less, amounted to, "Not as much as it could have been." That's not a cover-up. That's a man admitting torture like it was a routine part of the job, because as far as he knew, it was. The confessions extracted that way became the entire case. There was no other real evidence. And based on those confessions alone, all 3 men were convicted and sentenced to death. It went up on appeal and eventually reached the U.S. Supreme Court in 1936. And for the first time, the court had to answer a question it had never really been forced to confront. Does the Constitution care how a confession was obtained, or only whether one exists? The court's answer was unanimous. it does care. Using a confession extracted through torture, the justices ruled, wasn't just distasteful, it violated the 14th Amendment's guarantee of due process. The convictions were thrown out. For the first time in American history, there was now a hard constitutional line. Torture your way to a confession, and the courts won't let you keep it. That should sound like a huge win. And in one narrow sense, it was. 3 men avoided execution, and a legal precedent was set that still gets cited today. But notice exactly how narrow that ruling actually was. The court didn't say suspects have a right to a lawyer. It didn't say police have to warn anyone of anything. It didn't even say psychological pressure was off the table. All it said was, no torture, which left an enormous, obvious gap. If you can't beat a confession out of someone anymore, what if you just got smarter about how you pressured them instead? Someone was about to answer that question, and he wasn't a judge or a lawmaker. He was a polygraph examiner from Chicago. His name was John E. Reed, and before he became the most influential figure in American interrogation, he was a polygraph examiner working with the Chicago Police Department in the 1940s. Reed noticed something. The lie detector itself wasn't really what got people to confess. What worked was everything happening around it. The way he talked to people, the way he built false rapport, the way he read their body language, the way he made silence feel unbearable. So starting in the late 1940s and through the 1950s, he began formalizing all of it into an actual method. A repeatable, teachable system for getting someone to confess without ever laying a hand on them. It became known as the Reed technique, and it spread. Police departments across the country adopted it, trained officers in it, and eventually it became, quietly, without most people ever hearing its name, the dominant interrogation method in the country, one that in various forms is still taught to police today. Here's roughly how it worked. First, isolate the suspect, alone, in a small room, away from anyone who might offer support or perspective. Then, project total certainty about their guilt, whether or not you actually have the evidence to back it up. Cut off every denial before it finishes. Don't let the suspect settle into a comfortable no. Offer them a face-saving story. Maybe it was self-defense. Maybe it was a mistake. Maybe anyone would have done the same thing, so that confessing starts to feel less like surrender and more like relief. No hoses, no fists, no marks on anyone's body. Just hours of controlled psychological pressure, engineered by someone trained specifically in how to produce a confession. And think about where this leaves the Brown v. Mississippi ruling. That case banned torture. It said absolutely nothing about this. A suspect who walked out of a Reed-style interrogation room with a signed confession had experienced something the Constitution, as written so far, had no real language for. No blood, no bruises, just exhaustion, manipulation, and a piece of paper with their signature on it. And there was still no requirement, none, that police tell a suspect any of their rights before any of this started. No obligation to say, you don't have to answer. No obligation to say, you can have a lawyer here. The room was legally silent on all of it, and the only person who understood exactly how to use that silence was the interrogator. For over a decade, this went almost entirely unchallenged. Then, in 1964, one case out of Illinois finally forced the Supreme Court to ask a question it had been avoiding for 30 years. Not, was this confession beaten out of someone? But, should someone even be questioned like this before they've been told they have a right to stay quiet at all? The case was called Escobedo v. Illinois, and it started, like so many of these stories do, with an ordinary crime that had nothing historic about it at all. Danny Escobedo was arrested in Chicago in January 1960 in connection with the murder of his brother-in-law. He was taken in for questioning, and this part matters. He actually asked for his lawyer. More than once. His lawyer, for that matter, was right there, physically present at the police station, asking to see his client. He wasn't allowed in. Police kept Escobedo in an interrogation room, denied him access to the attorney standing in the same building, and kept questioning him until he made statements that implicated himself in the murder. Those statements became the backbone of the prosecution's case. His lawyers appealed on a fairly narrow but explosive argument. If a suspect has already asked for a lawyer, and that lawyer is physically present and being denied entry, doesn't the interrogation itself become unconstitutional at that point? Not, was the confession beaten out of him, but, should this even still be considered proper questioning once he asked for help and was refused? In 1964, the Supreme Court agreed with him. In a 5-4 decision, the court ruled that once an investigation stops being general fact-finding and starts focusing on a specific suspect, once it becomes accusatory rather than exploratory, that suspect has a right to a lawyer, and denying access to one they've specifically requested violates their constitutional rights. For the first time, the court had planted a flag beyond no torture. It said, at some point, procedure matters. Rights matter, even inside that closed room. But, and this is the part that made the next 2 years so chaotic, the ruling didn't clearly define when that point actually arrived. What exactly counts as accusatory versus investigatory? Does a suspect have to explicitly ask for a lawyer, the way Escobedo did? Or does the right exist automatically? What if someone doesn't know to ask? Police departments were left interpreting the ruling case by case, city by city, often in wildly inconsistent ways. Some read it narrowly. Nothing changes unless a suspect specifically requests a lawyer out loud, and one happens to be available. Others weren't sure it changed anything about their day-to-day practice at all. Lower courts split. Legal scholars argued. And meanwhile, the actual interrogation rooms across the country kept running mostly the way they always had. Because you have a right to a lawyer once things get accusatory is a very different thing from a police officer being legally required to say so, out loud, to every single person they arrest. The country needed a case that didn't just describe a right in the abstract. It needed one that forced the court to spell it out. Plainly, procedurally, in words simple enough that any officer, in any station, in any part of the country, would know exactly what they had to say and when. 2 years later, in a police station in Phoenix, Arizona, that case walked in. Ernesto Miranda was not a sympathetic figure. It's worth saying that plainly, because the story that made his name a household word has nothing to do with him being a good person, and everything to do with what happens in a room when the state has all the power and the person sitting across the table has none. In March 1963, Miranda was arrested in Phoenix, Arizona, in connection with the kidnapping and rape of a young woman. Police brought him into an interrogation room. There was no lawyer present. Nobody told him he had the right to stay silent. Nobody told him anything could be used against him in court. Nobody told him he could ask for an attorney before answering a single question. He was questioned for roughly 2 hours. By the end of it, Miranda had signed a written confession. And at the top of that confession, this detail matters more than almost anything else in this whole story, there was a typed statement claiming the confession had been given voluntarily, with full knowledge of his legal rights. He hadn't been told what those rights were, not once. The document said he understood them anyway. Based almost entirely on that signed confession, Miranda was convicted and sentenced to 20 to 30 years in prison. Here's where it gets interesting, and where the case stops being about Miranda personally and starts being about everyone. His court-appointed lawyer, a Phoenix attorney named Alvin Moore, didn't build the appeal around whether Miranda actually committed the crime. He built it around a much narrower, much stranger question. Does it matter that nobody told him his rights before he started talking? Up to that point, even after Escobedo 2 years earlier, there was still no clear universal rule, no script, no requirement that police say anything specific before questioning began. Escobedo had said, rights exist once things turn accusatory. It hadn't said police have to announce that, out loud, in plain language, every single time, to every single person, regardless of whether they know to ask. The case worked its way up through the Arizona courts, where Miranda kept losing. Eventually, it reached the U.S. Supreme Court, bundled together, in fact, with 3 other similar cases from New York, California, and the federal system, all asking some version of the same question. What exactly does police procedure have to look like before a confession can be considered fair? By the time oral arguments happened in early 1966, the country had already spent 35 years knowing interrogation rooms had a problem, since the Wickersham report, and 2 years half answering it with Escobedo. What it didn't have yet was one clean, unavoidable rule. Miranda's case was about to become that rule. Not because Miranda earned it through good character. Not because his crime was sympathetic. It wasn't. But because the question underneath his case was bigger than him. If the government can take away your liberty based on what you say in a locked room, shouldn't the government also be required, every single time, to tell you that you don't have to say anything at all? The Supreme Court was about to answer that question in a way that would outlive Miranda by decades and outlive the specifics of his own case entirely. On June 13, 1966, the Supreme Court handed down its ruling in Miranda v. Arizona. And it did not go the way most people expect when they hear the word landmark. It was 5-4, not a resounding consensus, not a unanimous statement that this was obviously, self-evidently correct. A single vote away from going the other direction entirely. Chief Justice Earl Warren wrote the majority opinion himself, and he didn't bury the lead. The core of it was this: whenever police take someone into custody and intend to interrogate them, that person has to be told, clearly and specifically, before questioning begins, that they have the right to remain silent, that anything they say can be used against them in court, that they have the right to an attorney, and that if they can't afford one, an attorney will be provided for them. Read that list again. That's the warning. That's the exact one you've heard 100 times on television, recited almost word for word, decades before most of us were even born. Warren grounded the ruling in 2 parts of the Constitution working together. The Fifth Amendment's protection against self-incrimination. You can't be forced to be a witness against yourself. And the Sixth Amendment's guarantee of the right to counsel. Individually, those amendments had existed since 1791. Nobody had ever required, until this exact moment, that police proactively announce them to a person the second they were taken into custody. The dissent was sharp, and it came from justices who weren't exactly hardline, including John Marshall Harlan, who called the decision a dangerous overreach that would handcuff police far more than it protected suspects. The core of the disagreement wasn't confessions shouldn't be voluntary. Everyone agreed on that much, going back to Brown v. Mississippi 30 years earlier. It was whether the court had any business inventing a specific, mandatory script that police across the entire country now had to recite, verbatim, in every single custodial arrest, or whether that was a decision that belonged to legislatures instead of judges. Warren's answer, in effect, was, "We've tried it the other way. We tried leaving it to case-by-case judgment for over a century. We tried it after Wickersham. We tried it after Brown. We tried it after Escobedo. And every time, without a clear universal rule, interrogation practices drifted back toward whatever pressure police could get away with, because there was no floor under any of it. So the ruling set the floor. Not confessions have to feel fair. Actual, specific, required words, spoken out loud before questioning starts. No ambiguity left for a police department to interpret its own way. No room for, well, we figured he probably knew his rights already. And notice what that actually solved. It didn't just protect people who happened to have a lawyer on hand, like Escobedo did. It protected the suspect who didn't know to ask, the one who couldn't afford an attorney, the one who had no idea silence was even an option. For the first time, the protection didn't depend on the suspect being savvy enough to invoke it. It existed automatically, the moment they were in custody, regardless of what they knew or didn't know walking in. That's the ruling that turned an unlikable defendant in a brutal case into the reason every arrest in America now sounds almost exactly the same. But Ernesto Miranda's own story didn't end with a Supreme Court victory. In some ways, it was only about to get stranger. Here's the part of this story that almost nobody remembers, and it's the part that makes the whole thing feel less like a tidy legal victory and more like something out of a Greek tragedy. Winning at the Supreme Court didn't set Ernesto Miranda free. It didn't erase what happened to the victim in his case, and it didn't mean he walked away from prison. All the ruling did was say his original confession couldn't be used against him, because he'd never been told he had the right to stay silent before giving it. So Arizona simply retried him, without the confession. Prosecutors built a new case using other evidence and other witnesses, and in 1967, Miranda was convicted again, verify sentence length in retrial, and sent back to prison. He was eventually paroled in the early 1970s, and once he was out, something almost darkly funny happened. Miranda started selling autographed cards, actual cards, with the Miranda warning printed on them, in his own handwriting, for a few dollars apiece to tourists and law students who wanted a piece of the case that made him famous. The man who never asked to become a legal landmark leaned into it completely. That's not even the strange part. In January 1976, Miranda got into a bar fight in Phoenix, a knife fight. He was stabbed, and he died from his injuries. Police arrested a suspect in connection with his death, and when they brought that suspect in for questioning, they did exactly what the law, Miranda's own law, now required them to do. They read him his rights, told him he had the right to remain silent, told him anything he said could be used against him, told him he could have a lawyer present, and the suspect used exactly that right. He stayed silent and asked for an attorney. Without a confession, and without enough other evidence to convict, prosecutors couldn't make the case. The suspect in Ernesto Miranda's death was never convicted of killing him. Sit with that for a second. The man whose case forced police, for the first time in American history, to tell suspects they had the right to stay quiet, was killed by someone who exercised that exact right and walked away because of it. It's almost too perfect to be real, except it is real. It's the kind of detail that sounds like it was invented for a movie, and instead just happened to be how one man's life actually ended. Protected in death by the very words he spent the rest of his life being known for. So step back from Miranda the man for a second, because this was never really about him. This is about who holds the power in the smallest, most closed-off room the justice system has, the one with no windows, no clock, no one watching. For most of American history, that power belonged entirely to whoever was asking the questions. The suspect didn't need to be guilty for that imbalance to be dangerous. They just needed to not know what they were allowed to do, or not do. And that imbalance didn't get fixed by good intentions. It didn't get fixed by a report, even a report as damning as Wickersham's. It took decades, and it took a strange, unbroken chain of ugly cases. A whipping, a denied lawyer, a 2-hour interrogation of a man nobody was rooting for, before the country finally built a floor under that room. A floor that doesn't depend on whether you're smart enough to ask for a lawyer or lucky enough to have one nearby. It's just there, automatically, the moment you're in custody, whether you know to use it or not. That fight isn't actually over, by the way. Courts are still narrowing and testing what Miranda covers right now in cases most people never hear about. What counts as custody? What counts as a clear invocation of the right to stay silent? Whether a suspect has to say the magic words exactly right, or whether police can talk around them. Most people who can recite the warning from memory have no idea it's still being fought over, or that it didn't exist for most of this country's history at all. Which is sort of the whole point of a story like this. The systems that feel the most permanent, the most obviously how things have always worked, are usually newer and stranger and more fragile than anyone assumes. If stories like that are the kind of thing you're into, there's more where this came from. Subscribe, and I'll see you in the next one.